The views and opinions expressed on this program are those of the participants and do not reflect the views of BronxNet or the program underwriters.
BronxNet. Your voice, your views, your vision.
Coming up, we remember 2012 as a year our nation endured numerous shootings that claimed the lives of so many. Why did they happen? Were all the shooters suffering from a mental disease? Is that even an excuse? Today we take a deeper look into the defense known as lacking capacity, also known as the insanity defense. We have a lot to get to, so stay right here because today's verdict starts right now. Today's verdict, the show that gives you your legal rights and options. I'm your host and trial attorney for the next 30 minutes, David Lesch. When a person commits a violent crime, many different defenses are pled. One such defense offered argues that although the accused did commit the crime, he or she should not be held legally responsible because they were unable to understand the consequences of their actions. But this is a very complicated defense. Many know it as the insanity defense. Before we decide that a person is legally insane, we obviously must determine what it means to be sane. On today's show, we'll be discussing the controversial insanity plea with our experts to better shed light on the issue. We have joining us today Associate Dean from St. John's University School of Law, Larry Cunningham, and Professor, I think we really need some guidance on the issue. Am I correct in saying insanity defense? I mean, it's okay to use that term. Am I correct?
Absolutely. Insanity is a legal term. You'll never find a psychiatrist using that term, but that's what we in the law call it.
I think we're going to be talking a lot about it on today's show and using that particular term. And it has been around for a very long time. Am I correct?
Since biblical times, actually. But we really know it as it in its current form ever since about the mid-19th century out of England, a case called Mcnaughton's rule.
Now, this Mcnaughton's rule is known in the legal community, but for the viewers, what does that mean?
So the English courts were confronted with a case where Mr. Mcnaughton had committed a homicide, and they had to determine to what extent should his delusions excuse him from criminal punishment. And so they came up with the rule that we actually have in New York to this day, which says that if a person doesn't know right from wrong because of their mental illness, their criminal liability is excused, and they get the insanity.
All right, well, that's a slippery slope in terms of knowing the difference between right and wrong. And correct me if I'm mistaken, but if you, for instance, argue that the devil made me do it, that's wrong. Am I correct? So therefore, you wouldn't be able to use the defense.
Right, unless the devil was telling you something and you had these delusions that you thought that it was okay to kill somebody or rob a bank because of those delusions. So it all turns on what was the defendant's mental understanding about what's right or wrong at the time. But in general, if somebody says that, I was just unable to control my behavior, that's not enough, at least in New York. Some states it is, for example, Connecticut. But in New York, you have to get the insanity defense, you have to not know right from wrong. Well, it's a very difficult standard to prove.
Let's take a step back a second, because let's tell the viewers, you have a little bit of a background in the Bronx with respect to this particular issue.
Right.
Tell the viewers where you worked before you were working at St. John's as the dean.
Yeah, I was a prosecutor in the Bronx District Attorney's Office, where, among other cases that I handled, were insanity defense cases.
Give me an example of somebody who might have come into the courtroom through their attorney or through legal aid, whomever, and said that they were claiming I was insane. Please don't put me in jail.
Sure. These were most often homicide cases. And very often they presented with extraordinary claims of mental illness, long histories of hospitalization, usually diagnoses of schizophrenia or schizoaffective disorder, other real major clinical disorders. And usually, I have to tell you, most often there was no dispute that the person should get the insanity defense. Very often, we resolved these cases with an agreement with the defense.
No, you don't see that on television, for
Right.
instance, on the legal shows that I'm sure a lot of people watch on TV. It's usually the prosecutor doesn't want this defense to come
Right.
in, wants to put them in jail, and it's the defense attorney who's pleading it. But that's not really the way it is.
Well, it depends on the case. Often in high-profile cases, you'll see public outrage when there's even mention that the person should get the insanity defense, because there's sort of a myth among kind of the general population that insanity defense means the person is getting off on a technicality. It's the farthest thing from the truth. When someone's found not guilty by reason of insanity, they are automatically committed to a hospital, a forensic psychiatric hospital that looks and feels just like a prison, and they stay there until doctors certify that the person is doctors certify and a judge finds that the person is no longer a danger to the community.
Okay, just from your experiences, seeing what we've seen on the TV lately with the shootings that have been going around throughout the country, are they insane? The people who are pulling the gun, who are shooting the guns, just from the mere act of shooting and doing this type of thing, are they considered just to be insane?
And here's the problem. A person can do a horrible act that seems crazy. No one could imagine going into an and no normal person could imagine going into an elementary school and killing 20 some odd elementary school children. But the fact that somebody does a crazy act, and I use crazy in sort of the pejorative term, doesn't mean that they are legally insane. Legal insanity is a much more difficult standard to meet. It doesn't mean being evil. It doesn't mean being wicked or wanton. It means not knowing right from wrong. And that requires really more of an assessment of the person than about the act that they do.
Okay, we actually have a lot more to get to with you, so don't go anywhere. We have to take a quick break, but coming up, does the insanity plea unfairly turn the offender into a victim? We'll be right back.
Missing anything in the first aid kit?
Yep.
Did you go through the plan with the kids again?
Yes. The more you prepare today, the more you'll be able to reduce the devastating effects of a tornado, an earthquake, a power outage, or any other disaster.
Welcome back. I'm your host, David Lesch. We at Today's Verdict want to hear from you, so send us your questions or comments to David Lesch at BronxNet.org or post a comment on our Facebook page at facebook.com/today'sverdict. Over the years, the insanity plea has faced criticism from both sides of the fence. Some believe that it can be viewed as a discriminatory bargaining tool, and others believe it allows criminals to receive lighter sentences. Before we reach our verdict, we need to visit one side of the discussion that might show the offender as a victim rather than a criminal. Joining us to shed light on the psychological aspect of an insanity defense is Assistant Clinical Professor of Psychiatry and Human Behavior at Jefferson Medical College, Dr. Neil Kay. Doctor, thanks for joining us. I see you. I don't know if you can see me, but I can see you. How are you doing?
The video's up. I can see you. It's great to be with you. Thanks.
Okay. Well, let's get into the mental aspect of this, because this really fascinates me. From the onset, I picture individuals who were accused of these crimes immediately trying to fake that they have some kind of insanity defense that they should be able to put forth. Do you find that you're meeting individuals who are trying to put one over on you?
Occasionally, yes, but as your guest also said, most of the insanity cases that are successful are agreed to by both sides. It's a rare defense. It's, again, something people don't understand. Only 1% of felony cases get an insanity case, and only a quarter of those, so a quarter of 1% are successful. they're usually actually poor, less educated white women who are the most successful. So this notion that rich people use this to get off is simply a myth, and that's not what the facts show.
Well, Doctor, when are you called into the picture? How do you get involved in a situation where somebody may be creating this particular aura of a defense?
So a forensic psychiatrist can get involved in one of three ways. Prosecution can call you, the defense can call you, or sometimes the court will appoint you to be their own expert. So the judge herself may have a question about the mental state of the individual at the time of the crime and want an expert to give her guidance.
All right, well, give me an example of somebody who you're asked to evaluate on the behalf, say we'll do on the behalf of a defendant. The defendant's attorney asks you to evaluate. What types of things are you talking to his client or her client about? What goes on in that evaluation?
So in the evaluation, we're trying to do a complete assessment. We'll review all of the records that are available. These people usually have mental health records that go back many years. There'll be the records of the crime itself. There might be video or audio. There are police reports. The forensic scientist, the forensic expert, wants as much data as is available to assess, because we're doing a retrospective look. Well, we can see the person now, and they may be insane or not insane while we see them. The question before the court and that we have to address is the mental state at the time of the event itself.
Well, Doctor, we had an expert on set just before who was talking about knowing the difference between right and wrong and how important that is in determining whether somebody will be successfully able to put forth that defense. How do you determine whether somebody might know the difference between right and wrong?
So right and wrong, that is one of the tests, and apparently it's the New York standard for the insanity defense. So did they know what they were doing was right or wrong based on whether or not they have a mental illness? Because you can have a mental illness and still know right or wrong. On the other hand, if the mental illness is making you think that something is right when it's actually wrong, that would be, at least under the law, the criteria to use the defense. But it's also important to point out that while there's always a shifting standard in terms of right and wrong and what's going on, juries actually respond to their moral sense of what's taking place more than what all the fancy legal and medical definitions are. So at the end of the day, it actually becomes a rather practical experience with jurors, more so than just the legal minutiae and medical definitions.
Well, let me ask you a question. You've seen the shootings that have been going on throughout the country. Do you consider them right from the onset to be insane, those individuals who are pulling the trigger, or is there more to it from your perspective?
Way more to it, and actually most of those people are not insane and will not be found insane, and most of them won't even use an insanity defense.
But it seems to me that is an insane thing to do, to walk into an elementary school and murder, 22, however many there were, children there were. That's insane, but you're telling me that somebody who does that might not be considered to be insane.
Exactly. So while you use the term insane or crazy in sort of the lay definition, maybe a pejorative way, the fact is, in terms of a medical definition, no, that's not insanity. And in terms of legal definition, it rarely is either. I like to draw the distinction between being bad and being mad. And that's bad, but it's not necessarily mad. And frankly, it rarely is mad. It's usually bad.
Well, you've testified before. Have you seen juries look, the other way at these types of defenses? Are they trying to give a defendant the benefit of the doubt when they're suggesting that they're insane, or are juries very, very skeptical?
Juries are extremely skeptical, but they're also very invested in this kind of case. They know the stakes are high. They find mental illness and things about their mind and their brain fascinating. So in cases with forensic psychiatric experts, the jurors do a great job. They pay very good attention. They follow things, but they also reach into their own background, their hearts and their souls, and they try to look at what they think is morally right under the circumstances, which is not any of the criteria that they're instructed on, but the research in this area shows that that's generally what they actually do.
What should a defense attorney be looking for if they want to put forth this defense? Should they be looking at the records first? Should they be quickly hiring an expert to evaluate? What's the first thing that the defense attorney should be doing when this client ends up walking into their door, or the client is assigned to them through legal aid or through some other entity?
Getting an expert involved, the sooner the better, is really the most important thing the attorney can do. The sooner we can see the person, the closer to the time that the crime was committed, the better our evaluation will be. If it's 2 years later and we're seeing the person, at that point, everything's been extremely contaminated. So getting us involved as soon as possible is the best thing that they can do for their client and for presenting their case.
Well, Doctor, we don't have that much time, but if you had to put a pulse as to whether or not this nation is moving farther towards accepting this defense or becoming a little bit more skeptical, where do you feel we're going as a society?
Actually, we've been studying this for the last maybe 100 years, and there has not been a great change. What does happen is that whenever an important or political figure gets an attempt on their life, so somebody like President Reagan gets shot, the public outrage and the Congress feels they need to make a change, and so they make a change in the standards and they play around with the definitions a little bit, but it doesn't actually end up changing the final outcome. So poor Queen Victoria, 4 attempts on her life, changed the law each time, but it never really changes the outcome because, again, at the end of the day, we look at behavior, we look at this knowledge, this cognitive prong, but then the jurors reach inside and they do what they really think is the right thing.
Well, Doctor, I want to thank you. I think you taught us a lot. We really appreciate it here.
Thanks. Pleasure to be on your show. Thank you.
Okay. We have to take a quick break, but coming up, we'll continue our discussing the insanity plea. We'll be right back.
Nice, Dad. Nice, Dad. Nice.
Charles!
Nice, Dad.
You don't have to be perfect to be a perfect parent. There are thousands of siblings in foster care who'll take you just as you are.
G morning, sunshine. Wakey, wakey. You up? What'd you dream about? Me? JK. Text me back. I'll keep texting till you wake up. Are your parents home later? Is this something I did? Exclamation point, question mark? Right, this isn't a joke. Hello? Text me.
Welcome back. I'm your host, David Lesch. We at Today's Verdict want to hear from you, so send us your questions or comments to davidlesch at BronxNet.org, and you can also follow us on Twitter at Today's Verdict. The deadly shootings that shocked our nation last year in Aurora, Colorado, and Newtown, Connecticut, reopened an awareness of mental illness. But does a mental illness automatically disqualify you from responsibility to society? Joining in today's discussion is Associate Dean from St. John's University School of Law, Larry Cunningham. Again, Larry, thanks for being here.
My pleasure.
Okay, let's get back to the law. All right, how do you plead this, by the way? Do you is it pled on papers? Do you walk into the judge and say, "I'm declaring my client insane"? How does this, from a procedural point of view, how do we get this going?
Yeah, the defense has to raise it. Depending upon the state, sometimes it has to be in writing. And the reason why it has to be raised well in advance of trial is so the people, the prosecution, has the ability to hire their experts and have the defendant evaluated, and they have the opportunity to gather mental health records or police records to help them with their preparation.
Well, if you do declare this as a defense and you open up the door, are you giving everything to the prosecutor to be able to look at, everything in your family history? Are you giving authorizations for your own parents and authorizations for brothers and sisters?
Probably not. Probably just for yourself. But the prosecution is going to start issuing subpoenas. Subpoenas are court orders issued by one of the lawyers to various parties. So the prosecution is going to start to subpoena school records, for example, because one of the things that the prosecution is going to be trying to determine, as your previous guest said, is this person malingering? Is this person faking? And so they want to try to establish, well, is there a history here of of mental illness. So they'll go all the way back to educational records and hospital records and police records, trying to find anything they can on this person. And then the prosecution is going to hire their own expert, their own forensic psychiatrist, to go in and interview the defendant.
Well, have you seen faking? Have you seen it? Have you seen?
Very rarely. Very, very rarely. It's a good forensic psychiatrist will pick it up in a heartbeat, because the person just won't say the right things.
And what about the jurors? What do they think about somebody who puts forth this defense? Certainly in the Bronx, are they more forgiving? Or are they less forgiving, really?
Well, most of my cases never even went to the jury because they were agreed upon by both parties. It was clear the person wasn't responsible because of their mental disease. But in general, I think jurors view the defense with a healthy skepticism.
Okay, let's get back to the shootings, because that's really what's been on the news, and we've been looking at it. It seems that many of these individuals who have done this, had either written notes or had known that somebody was going to go back to their home after the shooting and look at their computer. So, they destroy their computer so that there's no evidence. That alone is an indication that the difference between right from wrong. Else, why
Absolutely.
else would you, someone's coming to your computer to look at, to see what you've done.
Right.
Would that be evidence to suggest that somebody knows the difference between right and wrong?
Absolutely. And so things like destroying evidence of any kind, advanced planning in secret, these sorts of things indicate that the person knows what they're doing is wrong, and so therefore they have to hide the evidence. Somebody who's truly insane legally, they will just not care because they think that what they're doing is perfectly appropriate, perfectly legal.
So in conclusion, if it looks like it's premeditated and everything's been loaded up into the car for a day or two and a note has been written and a computer's been destroyed, that's a very strong indication that this person knew right from wrong.
Right, because it shows that the person had an organized mind, that they were really thinking thoughtfully through it. So that's going to belie their claim that later on that they were really in this disorganized state.
Very quickly, any final tip to an attorney who's looking at this and wants to put forth a defense for their client? Anything you would tell that attorney very quickly?
Work with your expert. Hire an expert as soon as possible and have them guide you in terms of the records you should be subpoenaing and the questions you should be asking your client.
All right, well, thank you very much.
My pleasure.
All right. When a community is hit with a tragic event like a deadly shooting, the hardest part of healing and moving on is talking to our children about what has occurred. The question we asked our expert is, what is the right way to talk to and guide your child through a traumatic incident? We asked Dr. Liz Lasky to give us some tips. Let's take a look.
This country is in a state of national trauma. And when we experience a trauma collectively or even individually, there are ramifications for that, whether they're emotional, psychological, or social. Something like being nervous about dropping your kid off is a direct really outcome from the Connecticut shooting, which is our most recent mass shooting in a school. And there, I wish that I had easy words to tell a parent about don't worry about it, or it's not going to happen again, because that's not reality and it might. And something like safety planning, of course, is so important, and having a safety plan with your child about if something happens, then this is what you do. If you see a stranger, this is how you can get help. If you see a man, for example, in your school with a gun, this is the plan, and this is why you practice lockdowns, and this is why you practice fire drills, and those types of things. Sometimes when a traumatic event like this happens, one of the most important things is time. And we heal. It is part of the human condition to heal through time. And it doesn't mean that we won't forget about it, but as time goes on, hopefully it will get easier for kids to get back into their routines, as well for parents to feel a bit more easy sending their kids to school. I think it is important to talk about these events with your kids, because when we don't talk about something, there's a lot of shame involved. And if we don't talk about traumatic events, whether it is a shooting all the way to a war, When we don't give voice to it, then it means that it didn't happen. So it's really important to talk to your kids about it. Now, it's important to talk about it in an appropriate, developmentally appropriate way. So should you tell a 6-year-old every single detail about the Connecticut shooting? Absolutely not. It's not developmentally appropriate. It's not going to be helpful. And if anything, it'll make them even more scared. But is it appropriate to talk to your 6-year-old about something bad happened, a man with a gun came into the school, and this is what you do if that happens, and create a safety plan about it? Yes, that's 100% appropriate. And also to explain to them that they are safe and their school is safe and it's okay to go to school. All of those things are an appropriate conversation. If a child is 12 and they know more details and they can read and they've read about it on their own, then the conversation or the context of the texture of the conversation might change a little bit, and you can really talk about the details, and you can really have a bit more of a sophisticated conversation about how they feel when they hear that news and what they feel like when they go to school. One amazing thing that a community can do when they suffer a trauma is to do a public art piece. So something like creating a quilt, or having everybody in the community paint a tile and creating a tile wall, or planting a garden. As a community, it is so important to come together to honor those who have been lost in the tragedy. And it's also a really important unifying, cohesion building activity for the community, because people are resilient and life goes on and we have to move on. And we do in many ways, but we also have to remember what happened and how these tragedies did happen. And something like a public art piece or a public garden is a beautiful way to honor those that we have lost and also to carry on with our lives with them in mind.
Well, that's all for tonight. It's time to deliberate. I'd like to thank all of our guests for joining us and, of course, you for watching. Remember, if there's a legal issue or topic that you would like to see on the show, email me at davidlesch@bronxnet.org. And until we see you again, always remember, know your issues, know your rights, reach a verdict. We'll see you next time.
I remember how much you said you liked mine. Oh.
You don't have to be perfect to be a perfect parent. There are thousands of siblings in foster care who'll take you just as you are.
There is also a very attractive extended warranty option that includes free service and parts for the next 5 years. But there's no need for you to get that. You failed to get the test you needed at the doctor that would have detected disease early enough where it could have been treated. So you won't be around in 2 years to see him grow up, which means the warranty would be useless. Okay, sign here, please.
For a list of tests every man should have, go to ahrq.gov.